The next case is Patrick Reich versus Manifold Cloud Services et al. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, or victims in your arguments. If you do have children or victims involved in this argument, you may refer to them by initials or by terms like the child. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honor. May it please the court, my name is Todd Mazzola. I am here on behalf of the appellate defendants, Manifold Cloud Services, True Blue Labs, William Steiger, and James Bergman. I would like to reserve 4 minutes of rebuttal time, please. The subject of this appeal is straightforward. The appellants believe that under the circumstances, the trial court erred in denying their motion without conducting an evidentiary hearing. The standard of review in this case is an abuse of discretion. The test, however, for determining whether a trial court abuses its discretion when a motion is made under the Ohio Frivolous Conduct Statute was articulated by this court in Servpro versus Kenny. That test is the trial court is required to hold a hearing when a motion for sanctions demonstrates arguable merit. A motion for sanction lacks arguable merit in situations where the motion demonstrates the absence of a triable issue on its face. Nearly identical test applies to Civil Rule 11. The Supreme Court determined in a case called State Ex Rel. Eving versus Ricketts, and I'm quoting, if an arguable basis exists for an award of sanctions under Civil Rule 11, a trial court must hold a hearing on the motion. I'm going to a little bit elaborate on the word trial that they stated there. There are some allegations, I believe, that have been made in the appellee's brief that the motion required support, evidentiary support in the form of affidavits and otherwise for the court to grant a hearing. The 10th District Court of Appeals in a case called Tosi versus Jones, which I believe is cited in my reply, addressed that issue and held that a motion for sanctions does not require a movement to provide a list of evidence in support of those grounds to warrant a hearing. They did it in a list. Obviously, that's one step removed from actually requiring the evidentiary submission to be attached. This appeal involves violations under subpart A, 2A, and then I'm going to do the Romanettes, I, 3 and 4 of Ohio's Frivolous Conduct Statute, and Civil Rule 11, B1, 3, and 4, all of which involve factual questions for the court's resolution. In this court, the trial court proceeded to make findings on those issues without conducting a hearing. Again, we're not, in this appeal today, we are not suggesting that this court should reverse and enter judgment. We respect the fact that the statute itself requires an evidentiary hearing before sanctions can be awarded. What we're saying is that the court, what we're asking for is the court to reverse and remand for a hearing as required by the statute and by the cases that I've just cited. The defendants demonstrated arguable merit with respect to Reich's wrongful termination claim. On March 28, 2022, Reich filed a civil complaint alleging that he was wrongfully terminated from Manifold in November 2021. He reiterated that wrongful termination allegation in another motion almost a year later in a motion to appoint receiver. That motion was filed 2 months before trial was to be scheduled. Why that is important, I'll address a little bit later. In that letter, Reich said that he was unfulfilled with his position, he was not meeting the company's expectations, and that he was going silent with respect to his job responsibilities to seek employment elsewhere. Same letter, Reich asked that he continue to receive salary and benefits despite the fact that he wasn't performing any responsibilities of his position. In fact, Reich was not...
Counsel,
yes.
I just want to stop you because do you know where the letter is trying to find it in the brief now, where it's copied and pasted, so that we have the actual language. Because as I recall, the actual language says he's going to stay silent to the operation of the business, but he will continue to perform his responsibilities and duties.
And I don't deny that that's what the letter said, but in fact, he did not, within 2 weeks after that, perform his responsibilities. In fact, hadn't been performing the responsibilities of his jobs prior to that. So in combination with the fact that he was actually not performing his job responsibilities and submitted this letter that in all other respects reads as a resignation letter, it was clear that he in fact resigned his position.
But I guess what I'm trying to come around to is what really happened here. And
Yeah.
I guess I'm thinking here, to me, your whole argument is that this was frivolous because he resigned his position with that letter.
Correct, and with his actions.
Okay, well, that's a completely different thing, isn't it? Because,
I think the two were in combination.
right, but you can, I'm sorry, I don't mean to step over you and speak over you, but
Okay.
you can have a wrongful termination suit be filed on the basis that you didn't perform your duties, okay? So you're saying a combination, he filed the letter, he sent the letter, and then he stopped performing his duties.
Well, I think actually he stopped performing his duties and wasn't performing his duties even when he sent the letter.
Well, that's fine,
Yeah.
but the point is, he disagrees with that.
Correct.
Okay, so you file a wrongful termination because you say, I was performing my duties.
Let's put it this way. I don't believe he ever has stated on the record that he disagrees with that he says that he was performing the duties of his job. That's never been the argument. Instead, they've carefully worded their responses around that. In paragraph 22 of the complaint, the way they stated it is Mr. Reich expected continued employment as part of his membership benefits flowing from his monetary investment in Manifold. In response to the motion for sanctions, they stated that Mr. Reich had reasonable expectations of professional consideration in all company matters.
Right, because he's not just an employee that's quit. In this case, he is an owner of the property, or of the business, right?
Right, he
So
is.
he does still, even if he said, I'm not, gave this vague letter about what he's doing and what he's not, there's still duties owed to him by the company, right?
There are duties owed to him by the company, but the operating agreement that's actually attached to his complaint specifies what the duties are to him with respect to receiving any kind of salary or compensation from the entity. And that's section 4.4 of the operating agreements of both Manifold, for which he had a position, and True Blue. And it states a member is entitled to compensation from the company only for services that he renders for the company. He wasn't rendering any services for the company. This issue is not about whether he was getting credited for the profits of the profits and the losses of the company pursuant to membership interest. This is the request for salary and ongoing benefits, despite the fact that he was not performing any services for the company.
Counsel, didn't he include something about trying to work toward a seamless transition with others?
I'm not sure if the letter addressed that. At least I don't recall there being language in the letter saying that. I guess there was something that he stated that he wanted to offload his responsibilities to another employee, if that's what you're referring to. I don't believe that there was any real attempt to do that or to fulfill the positions of his position of responsibility, either before or after that resignation letter was tendered. So anyway, we believe that, as set forth in the brief on that prong, that Reich's filing of his complaint and continuing to allege wrongful termination in the motion to appoint a receiver over a year after all these facts became available to him and his attorney was frivolous, both under the frivolous conduct statute subparts A, triple romanet, and quadruple romanet, and Civil Rule B4 and B3, Civil Rule 11, B4 and B3.
Counsel, I know there was a hearing in regard to whether there should be an appointment of the receiver. Were there any other evidentiary hearings?
Not that I'm aware of, that was the only evidentiary hearing that was held in this case. A trial was originally scheduled for July, just 2 months.
So there wasn't any motions? Was there a motion practice, motions for summary judgment?
There was not a motion for summary judgment in this case, no.
All right, then I want to make sure, so we'll have a transcript of that magistrate's hearing with regard to the appointment of the receiver?
Yeah, it is, I believe, item 77 on the docket. It was filed
Right.
by the appellee in this case.
But it seems like both sides are saying that in regard to the appointment of a receiver, that there was some evidence presented in regard to what his role was with the company, what his duties were, and so forth.
That was mentioned in the motion. It was not addressed at all in the hearing. They seemed to abandon that as grounds for the motion when the evidentiary hearing came around because they didn't produce any evidence on it.
Thank you.
And that was not the subject, the main subject of that. I'm going to move actually to the motion for sanctions itself.
Just to give you a heads up, you're
Yes.
moving into rebuttal time.
Goes quickly.
Yeah. Okay, I will then reserve my rebuttal time and submit the remainder on the strength of the brief. Thank you.
Good morning. May it please the court? Excuse me. Good morning, Judge Lanzinger, Judge Sutton, Judge Carr. May it please the court? My name is Jim Langendorf, and I represent the appellee, Patrick Reich. And I'm here to give you 3 reasons why this court should affirm the trial court's decision below. First, the abuse of discretion standard of review. Second, the judge's review and order were complete, lawful, and proper. And third, the appellants have not given this court any rationale or cause to reverse the decision below. The appellants agree that the standard of review is abuse of discretion. That's a standard deferential to the trial court and a significant hurdle for the appellants to surmount. An abuse of discretion is more than an error of law or judgment. It implies the court's attitude is unreasonable, arbitrary, or unconscionable. And when applying the abuse of discretion standard, appellants courts should not simply substitute their judgment for that of the trial court. Instead, in order to establish an abuse of discretion, the result of the trial court's decision must be so palpably and grossly violative of fact or logic that it evidences not the exercise of will, but the perversity of will. Not the exercise of judgment, but the defiance of judgment. Not the exercise of reason, but instead passion or bias. Have the appellants shown this court that Judge Rowland defied rational judgment out of passion or bias or perversity of will? Mr. Reich argues no, they have not. In the context of the standard, I turn to reason number 2 to affirm the trial court's decision, and that is the motion, how she handled the motion and the order. She took in the motion, she reviewed Mr. Reich's response and Manifold's reply, and granted there was no evidence supplied. We weren't asking that there must be evidence supplied, it's just a note that there was none. And in cases where this court has reversed denials of, or a denial of a motion for sanctions, it's been because there has been some significant evidence in the DiCarlo case. Then, but moving back to this, in the order, the judge summarized the 10 proposed violations of the frivolous conduct statute and the 3 proposed violations of Civil Rule 11. She discussed the pertinent facts gleaned from her and her magistrate's proximity to the parties, the attorneys, and the proceedings. Then she discussed the statutory definitions of frivolous conduct and the 3-part process she was going to use deciding on those grounds. The process she used was from Carbone versus Nueva Construction, and it required the court to first determine if there was frivolous conduct, whether that conduct caused any harm, and what, if any, sanction is appropriate. Then she laid out the subjective test required by Civil Rule 11. It's a little tighter than frivolous conduct. That requires something quite a bit different. It requires a showing that the attorney didn't read the pleading, had no grounds for it, or interposed it for delay. After all that, and after her closeness to the proceedings, which had gone on for over a year, the order said the court found no frivolous conduct and no violations of Civil Rule 11. Now,
Counsel, can you talk to me a little bit about the need for a hearing? Isn't there a need for a hearing if the motion for sanctions demonstrates, unless the motion for sanctions demonstrates a complete, an absence of a triable issue on its face?
so if there's something arguable or triable on its face, that is an issue of fact, which the judge at that point has discretion to determine. So if she finds that there is none based on her proximity, on her, the parties, the attorneys, and the proceedings, if the trial judge finds that there is nothing there, they are free to grant the motion without a hearing. The jurisprudence is fairly solid that there is no requirement that the court grant a motion for sanctions unless they're going to grant sanctions, and then they must. But she didn't find it. And again, the word is arguable, and if it's arguable, then that means it could go either way, and that at that point, that is that judge's call. Did she find them? No, it's her call. Those aren't issues that go to a jury. They're up to her. So I believe that her discretion that she has and the deference that this court will show to her allowed her to make that call. On the Rule 11, the case been going on for over a year. During the process, the appellants had made no claims during the course that there was a Rule 11 violation, that there was frivolous conduct occurring during the case. There were no evidentiary hearings other than the motion for appointment of a receiver. There were no depositions taken. There were no allegations of false affidavits. There were no missed meetings. There were no repetitive motions coming up before the judge again and again. And there was nothing submitted to that effect. The appellants gave the court no reason to believe that there was anything going wrong. There had been 2 final pretrial conferences. Both parties had submitted a trial brief. We'd exchanged jury instructions. Up to that point, again, there was nothing, no indication that Mr. Reich or I had done anything wrong. No allegation that we had. And on all of that, the judge was well within her discretion to deny the appellant's motion without a hearing. And that's Harold Pollack versus Bishop, Giusti v. Felton, Slattery versus Seamray. All of those cases give the trial court discretion to deny a motion for sanctions. The appellants disagreed, but that's not their judgment that this court is reviewing, despite their efforts to the contrary. Which leads me to reason number 3, that they've given you no reason to reverse that decision. The appellants left all but 2 of their allegations that they made in their motion behind when they came to this court. All they brought was the wrongful discharge claim and the motion for appointment of receiver. You asked about it, they've talked about it, that's the wrongful discharge claim. Judge Rowland specifically discussed that claim in the October 18th memo that she was talking about. You've asked about it here, and that is on page, it's included in the appellant's brief, and it is restated there. In the meantime, I will continue to maintain, it's on page 3. I will continue to maintain my current duties and work on transferring what I can to Val to make it as seamless as possible. Obviously, I need to stay on payroll until I can line up another job. Hopefully, it doesn't take too long. You asked about duties that he was or wasn't doing, and the appellant's counsel said that it says his understanding that Mr. Reich had stopped doing anything beforehand. That's not part of the record as a motion or in the brief on appeal. But Judge Rowland's discussed that claim, Your Honors. And the trial judge does not need to identify every piece of evidence they rely upon when they're making a judgment. But she still covered the facts in the law. She found that there was a basis for bringing that alternative remedy, and she found that it was not interposed with malice or intent to delay. She also found that it was not a claim that no reasonable lawyer would make. And Mr. Reich has pointed out in his affidavit and in his brief that email does not tell his 4 partners he's quitting or resigning. No word of that finality exists in that email. He doesn't say he quit. He doesn't say I'm resigning. He just says, hey partners, professional notice here. I'm going to be changing out because this isn't working for me. But in the meantime, I'll need to stay on the payroll till I leave. He's one of 5 owners. He owns 20%. He's got $100,000 in this. and he was doing a job for which he was being paid $100,000 plus a year, receiving health insurance benefits, and doing significant work. And, as noted, Crosby versus Bean says that a majority shareholder in a small corporation cannot discharge a minority shareholder from his job, or her job, unless there is a legitimate business purpose. There's been no argument of a legitimate business reason in the answer or in the brief. There was no evidence before Judge Rollins on the motion for sanctions that there was a legitimate business reason. If they had such evidence, though, they should have given it to her at the time. They've only raised the possibility this evidence exists in their brief. This is for the very first time they say, hey, if you hold a hearing, we would definitely show you evidence that Mr. Wright wasn't working before we let him go. Well, this is no time to let that loose. But from this allegation, Your Honors, there flows a deeper question. If Mr. Wright's wrongful discharge claim was so feeble, so weak, so dependent upon that email, why wouldn't the appellants have raised that at the trial court level? Why wouldn't they have said, hey, there's no claim here, file a 12B6 motion. That's what that's for, get rid of frivolous claims early. If they didn't have that email and the complaint, they could have filed their answer and attached it and then moved for judgment on the pleadings once they had the whole pleadings together. They didn't. If that didn't work, they could have filed a motion for summary judgment, took all the evidence after discovery and said, hey, there's no genuine issue of material fact. This claim has no life left. It should be dismissed. Nothing. What they did instead is they brought it to the trial court to punish Mr. Wright exactly as this court says they shall not. They weaponized the 2323 statute to make it difficult to ask for sanctions and to include a Rule 11 proceeding with it. The wrongful discharge claim had a good basis in fact, still does. The judge recognized that, and it has a legal basis in Crosby versus Bean. Now finally, the receivership. The appellant say Judge Rollins abused her discretion by not finding the filing of that motion or claim was frivolous and in bad faith. In support of that, they rely on their interpretation of the receiver statute. And they said Mr. Wright didn't put on the appropriate evidence to get that motion granted. The receivership statute allows a court to grant a receivership to a member or partner of an organization if they show that there's waste or damage or the risk of loss of a common fund, or in any case where equity has been used, or where equity is granted a receivership. That's a very broad range for a trial judge to determine whether or not a receivership is available. Mr. Wright did go on the stand at that point, after filing an affidavit. He did go on the stand and he testified that he did not receive documents that he was supposed to receive under the terms of the operating agreements on time. And they're not minor documents, there are independent accountant's documents about the condition of his investment. He didn't receive tax information on time so he could file his taxes at an appropriate time. And he didn't receive, and he says he didn't receive tax payments that he was entitled to under the terms of the operating agreement to pay for his income taxes. Furthermore, he went on to say that he got a call from a former client of Manifold Cloud Services that said, hey, I spent $150,000 in this company and I didn't get what I paid for. What are you guys going to do about it? He had to tell him I don't work for the company now. And then when Mr. Steiger, one of the appellants, one of the defendants, got on the stand, he agreed. I never sent those documents in a timely fashion. I didn't send them out. We couldn't afford an independent accountant, even though there's no I can't afford it clause in the operating agreements. And he admitted he didn't get the tax information on time. He also admitted that guy did call him and did say, hey, where's this, I gave you $150,000 and you didn't do the work for me. All of those things were rationale for Mr. Reich to be asking for protection of his assets. They also said that there is a clause in the operating, when I say they, the appellants also say there's a clause in the operating agreement that Mr. Reich didn't abide by. It was one that required a unanimous vote in order to seek a receivership. That makes sense in the context of that clause where it says no one can do that for the company on behalf of the company without a unanimous vote. Mr. Reich testified and has maintained, I moved for that receivership for myself to protect my interests in my investment. And the appellants were advised of that. Mr. Reich said that. Crosby versus Bean again gives a minority shareholder a right to come forward with a direct claim that would include something to that effect. It would make no sense for him to require a majority vote to protect his own interests against the people who were taking it away. Now, this statute left plenty of room for the judge to determine whether the applicant, whether he needed that remedy. Mr. Reich supported, the court's review of the parties, the attorneys, and the proceedings, both in the wrongful dismissal and in the receivership. The court had a great look at it, was with us all the way. Magistrate Hom, Judge Rollins, they were in it. We all dealt with them. There should be no problem having them, no question that they knew what was going on. The court determined that that receivership was not frivolous or in bad faith, and this court should affirm that. And the appellate, and on this, I gotta talk about Civil Rule 11 for just a sec. There is no evidence at the motion or before this court that suggests that I, James Langendorf, because that's who Civil Rule 11 applies to, that I filed something without reading it, or without knowing what it was about, or that I did it for delay. Nothing to that effect. And without evidence, I'm struck by the irony that that claim comes now to this court, first to Judge Rollins and now to this court, without evidence. The appellants have not presented evidence sufficient to overcome the abuse of discretion standard, and instead to support their appeal, they've come only with arguments, supposition, and speculation. I believe this court has an easy path to affirming the trial court's decision, denying sanctions, and Mr. Reich and I respectfully urge it to do just that. Thank you.
You have about 4.5 minutes.
Okay, thank you. Your Honor, one thing we didn't hear when he got back up here is any claim that Mr. Reich was actually performing the duties of his position before or after he tendered the letter that signified that he was resigning and going on to look for another position and going silent, which is the words that he used in the actual letter itself. Again, he says that the motion and the brief don't state that that was the case, that he actually resigned. Both of them used the term resign in there and suggested that he resigned. What the resignation letter did is it gave a point at which the court could determine that it was that the attorney that was filing and the person themselves knew that claim to then later say that they were entitled to ongoing payment for the position that they weren't actually performing services for was appropriate, either, especially in the face of the operating agreement, which stated that you only get compensation for services that you render to the company. As far as the abuse of discretion standard that he was citing, there is specific context-specific case law for this, and that's, does the actual motion present arguable merit? He said over and over in arguing this, evidence, they didn't produce evidence. That's not the standard that this court has determined or the Supreme Court has determined in either of these. There was some discussion about the trial court's closeness to the proceedings. In this fact, the only proceeding actually was held by the magistrate, since there was no objections to that. It never got to the trial court judge in this case. There's some suggestion that we should have filed a 12b-6. 12b-6 doesn't resolve the evidence of the case or the facts. It assumes that the facts are correct. There's a suggestion that there should have been a motion for summary judgment filed. Now, perhaps that could have been done, but attorneys determine when they're trying a case on behalf how they can do it in the most in the most cost-effective manner. In this case,
just out of curiosity,
yes,
when we reviewed the transcript,
yes,
for the hearing in regard to whether a receiver should be appointed, are the words frivolous used?
I'm sorry, I didn't follow.
The counsel used, put into evidence the words frivolous. and when I review that transcript, am I gonna see any word called frivolous at the evidentiary hearing itself?
I don't know that there was argument made, as far as that goes.
Wouldn't there be an argument as to whether a receiver was required?
There was definitely an argument as to a receiver would be required. I think, Your Honor, that one of the things that the court should consider in this is that the plaintiff himself withdrew that motion for receivership just 13 days after the hearing.
Right.
He states in his, in the argument that, there were documents that weren't turned over. Well, those were all documents that were actually turned over, not just before the receivership, but actually before the case was filed, before the civil complaint was filed. The only thing that was new in that whole allegation was this claim that he received his tax distribution for that year, which was 2022, in time to file, in time for the taxes, which were due, I think, on the 18th of that year. But he didn't get a corresponding K-1 schedule. But he also testified that they typically did the tax filings on extension. There's no evidence, and in fact, he received that information.
The only reason I asked the question about frivolous is because they've made the allegation that you can look through the record, and there was no indication that at any point that appellant indicated that the whole lawsuit and motion for receivership and so forth was frivolous.
I think through the argument and through the actual evidence that was presented in the cross-examination, it demonstrated that the claims were frivolous.
Well, usually we have people saying stuff is frivolous when it's just full of merit, so I'm just.
Yeah, I mean, I don't recall.
I'm just kind of surprised if something was really frivolous if you don't even say to the court, this is frivolous. That's okay, we'll.
Yeah,
we'll review that.
it could be like, but I don't think there's a requirement that,
Okay.
before you file an actual motion under either of those, that you have to declare in the hearings that it's frivolous. I mean, the court decides the issues, whether it's frivolous or not, and it's usually after there's a ruling and the court's gotten to a point where you file that kind of motion, and here it was timely filed after a voluntary motion to dismiss was entered in this case.
And you're out of time, so if you could wrap up in the next 10 seconds.
Yeah, so with that, I would submit the rest of my argument based on the brief, and thank you for your time.
Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and the opinions are posted on the Ohio Supreme Court website. Thank you again.
Thank you.
Thank you.